Well, welcome, Facebook viewers. This is our Bond and Botus Law Offices Facebook Live, first one of the new year. We started up back at the beginning of 2020 when a lot of folks were spending time at home. And since a lot of us are still working remotely, we're going to continue with these Facebook Live episodes going forward. Folks, today I am joined by my good friend and law partner, Robert Reese. Robert and I have practiced law together for well over 20 years now. I have watched his family grow up, his kids grow up. Robert's wife, Becky, is also a great friend. His son, Austin, is my godson, and his daughter, Bishop, beautiful young lady that is in college and getting close to finishing. Robert helps people with money problems. He is a consumer bankruptcy attorney and one of the best in the state of Alabama. Robert, welcome to our Facebook Live.
Thanks, Brad. It's great to be here and joining you in the new year.
Robert, why don't you tell our viewers just a little bit about your background, where you're from and where you went to school, and let them know a little bit about you.
Sure. Grew up in North Alabama, grew up in Huntsville. Went to college at Jacksonville State over near Anniston, Alabama. Then moved here to Birmingham to start law school at Cumberland. Ended up finishing my law degree at Birmingham School of Law at Night Law School. And during that time was married. I've been happily married for going on 31 years now, or 31 plus years. 2 children, Austin and Bishop, both in college at Mississippi State University. Both will be graduating, one in the spring and one in the summer.
Wow. So you get a raise at that point.
Get an increase in wage.
Disposable income anyway.
Yeah, that's right.
They are both great kids. I've watched them. Of course, knew you and Becky before either were born and watched them grow up, and it's been a lot of fun. I don't know how we've gotten to this age or the point where we can even talk about that, Robert. But thanks again for taking time to join us today. So for our viewers, the Bond and Botus Law Offices are located throughout Alabama, throughout Mississippi, and we're in the Knoxville area in Tennessee. And folks, we help people with money problems. And with all that's gone on over the last 8-9 months, we know a lot of you are experiencing money problems. Our offices are offering absolutely free initial consultations at this point. And not only are they free, but we'll do them from the comfort and safety of your own home, your own office. We'll do it by phone, and we'll do it by video like we're doing today. But I want to encourage you, be proactive. If money is a problem, I know the word bankruptcy is a scary word. I know the last thing you want to do is even consider talking to a bankruptcy attorney. But if, and we'll talk more about bankruptcy and how it may be able to help today, but if bankruptcy is even potentially an option, I encourage you to reach out, talk to an attorney now before things get bad. Again, we'll just talk with you. If bankruptcy is not the right choice, we'll tell you. But if bankruptcy can help you, we'll also tell you about that. We're going into 2021. It's a new year. Some new checks have just come out from the government, starting to hit people's bank accounts. But we really don't know what the future will hold, and we don't know whether any more stimulus will be provided going forward. So I thought today would be a good day just to focus on our bread and butter, what we do to help people. And again, we're fully aware that bankruptcy is not something that people want to talk about, but it is important. Bankruptcy provides an important safety net, and Robert and I are just going to talk about how bankruptcy may help you today. And if you have questions, feel free to post them. Some questions we've already received. We'll get to those later during the episode. But again, please feel free to ask questions if you have them. So, Robert, as we go into 2021, we know that there have been a prohibition or there have not been a lot of foreclosures going on in the past year, although people are certainly behind on their mortgage payments. There have been reductions on people being evicted from homes that they're renting. But those are not going to last indefinitely. People are going to have to start addressing some of the bills that have piled up over the last year. So let's just kind of give a overview of how bankruptcy works and how it may be beneficial to people. Robert, I would say, and I'll let you speak to this, but I would say that the thing that drives people to our offices, that causes people to reach out for help more than anything else, are those persistent creditor phone calls and letters from collection agencies. So when somebody comes in and they're facing that type of pressure, what do you tell people?
Well, I'll tell them first, that we most likely help them dealing with those creditors and the phone calls. And I want them to know there are options out there. So we want to look at, those available options. And as you said, if bankruptcy is not the right option, then we'll tell you. If we think it's a good option for you, we'll tell you that as well. And, the worst thing you can do is stick your head in the sand and just not take some proactive steps to deal with the debt. So I just always want to make that, crystal clear to people. Don't be afraid to reach out. Don't have fear.
Yeah. What is the and I like to say there's nothing any attorney can do more quickly and more beneficial to an individual than obtaining the benefit of, and we'll use the legal term initially, the automatic stay. But if you could elaborate on what that means, when it goes into effect, and what it means to people.
Sure, Brad. I appreciate you asking that question and bringing that up. Yeah, when somebody files a bankruptcy, whether it be a Chapter 7 or a Chapter 13 debt consolidation plan, there's a federal law that goes into effect. We call it the automatic stay. And what it does is it stays or stops your creditors from continuing adverse actions against you. The phone calls, the letters, foreclosures, repossessions, garnishment of wages, or even bank accounts, all that must stop. And a lot of people don't realize that the filing of a bankruptcy will stop our good friends at the IRS from demanding back taxes from you. And so it's a very powerful tool that we have, a law that we have that we can offer people. So again, that's why you need to reach out with somebody with experience in this area of the law and who understands, and may has seen your situation more than once and knows, where your case would be headed. It's got that experience, and I think that's so critical. So that's why you need to reach out to us. I think we're one of the best firms around. And so please reach out to us.
Well, I absolutely believe that. The attorneys in our office in Birmingham, Alabama, specifically, we have, and hard to even say this, Robert, but amongst the four of us, we have almost 100 years of combined experience. We've been doing this for a long time. And it's important, folks. I will tell you, when there are a lot of folks with money problems, there are new attorneys that say, well, boy, I think I'll get into the area of bankruptcy practice. And they try to learn how the practice works. Having somebody that is experienced and knows what they're doing. Robert's been working with our judges in the bankruptcy judges in the Northern District of Alabama, in the Southern Division and Western Division for decades. He knows the judges, he knows the trustees, he knows how things work in Birmingham. So if you're in the Birmingham area and you need some help, reach out to our office in Birmingham. But again, we're offering this help with experienced attorneys throughout Alabama, throughout Mississippi, and in the Knoxville area in Tennessee. And all you need to do is call the phone number on your screen or go to our website. There's a form there you can fill out and just ask for somebody to follow back up with you. We have a lot of information on our website. I do want to encourage our viewers, perhaps you're not having money problems, but you know somebody that is. This video will live on our firm's Facebook page and on our website. So if you know somebody that may benefit, please encourage them to watch this. You know, one of the discussions we have with people when they come to see us is we try to give them an overview of the types of bankruptcy and how they work. I know you've done this hundreds, if not thousands of times. Give us a quick overview of the type bankruptcies available to consumers and just generally how they work.
Sure, Brad. And first off, let me just tell everybody, remember, when you call us and schedule an appointment, that first consultation is absolutely free. All it's going to cost you is your time and a little bit of effort to give us some information. But at that first consultation, and we look at your overall financial picture and then just lay out two bankruptcy options that are available, which is one, Chapter 7, what we commonly refer to as straight bankruptcy. And then we also will look at the Chapter 13 option, which is simply a debt reorganization, debt consolidation plan, where you typically will repay your creditors over a period of anywhere from 3 to 5 years. There's some factors that determine the length of that proposed plan, but that's kind of just a nutshell version of what we look at and what options are out there. And then if there's a non-bankruptcy option that we can foresee, we'll sure recommend that.
Absolutely. I tell folks all the time, I make a living by filing bankruptcies for people, but the first thing I'm going to do is try to keep you out of bankruptcy. Bankruptcy should never be your first option. On the other hand, it's important to know how bankruptcy works and what it can do. So make sure you understand the process just as fully as possible, and don't depend on your uncle or your cousin or your cousin's friend to tell you how bankruptcy is going to impact you. We're offering these free initial consultations. Call and we'll talk to you based upon our experience and knowledge of the bankruptcy laws. Robert, COVID has obviously caused a lot of medical problems for a lot of people, health-related charges. I would say that a fair amount of people that come to see us are there because of medical debt and other expenses related to being sick. A lot of people think that medical debt is somehow magical or special in bankruptcy, but we can deal with medical debt. Tell us about that and how it would work.
Yeah, well, medical debt, along with other debt, is typically in a let's just use Chapter 13 debt consolidation, debt reorganization plan. A medical debt is something that can be paid through that case and dealt with, so that you're not overwhelmed by thousands of dollars in medical bills, and then those being turned over to third-party collectors who will call you throughout the day and basically call you several times a day, and at some point it becomes overwhelming. So we can deal with medical debt that is owed by anyone, along with the other debts. And again, using Chapter 13 as an example, we can take those medical bills along with other debt and consolidate it into a much more affordable payment. And COVID has caused people to be laid off and only receiving unemployment. But even if you're laid off, Chapter 13, but you have a source of income, Chapter 13 is an option. And of course, we'll also look at Chapter 7 if that's a better fit for you and your goal. And, we just like to lay out those options for you. And I find most people know what's in their best interest and can decide for themselves based on good, solid information they've gathered.
And just to elaborate and add to what you said, even though you're perhaps paying the debt back through a Chapter 13, the significant thing about medical debt is just like a credit card payment or a loan from a loan company, it's an unsecured debt, which means if you're paying it back through a Chapter 13 bankruptcy, you don't necessarily have to pay it in full. You might only pay a small percentage or nothing at all towards the medical debt, but still be able to get rid of the debt, whether it be through a Chapter 13 reorganization or through a Chapter 7 straight bankruptcy. Robert, we talked about people being behind on mortgage payments, and we're starting to see, in fact, I just blogged about this during the last week, an increase in foreclosure proceedings across the Southeast, certainly within the states of Alabama and Mississippi and Tennessee. So if somebody comes to see you and they're facing a foreclosure proceeding, what can you do to help them?
Yeah, sure, Brad. The great thing about filing a bankruptcy is it will stop that foreclosure. Just within the last couple of weeks, I personally have filed a couple of cases to stop foreclosure. So they are starting back up. So so if you're behind on your mortgage payments, there's at some point I would expect your mortgage company to start a foreclosure proceeding. And the great thing about it is we can stop that. And under a Chapter 13 reorganization, we can catch up those back house payments through that reorganization and really just give you a fresh start on your mortgage. It's a great tool to save a house if you're facing that. The key is if you're behind, you need to be talking to an attorney about what your options are. So you don't get you don't want to lose your house to foreclosure when filing a bankruptcy may have saved your house. So don't procrastinate and wait till there's a foreclosure in 3 to 5 days.
That's right. Yeah, it's we can stop the foreclosure up until right before the foreclosure sale takes place, but again, this is one of the areas you need to be proactive because it's much better if you get to the attorney well ahead of time. And I encourage you, reach out if you're behind. Even if bankruptcy isn't even remotely on the horizon for you, we'll let you know how it works and how you could stop a foreclosure if it became necessary. It might even be something you can use in trying to negotiate a forbearance or some sort of modification with your mortgage company. So reach out, ask questions.
Yes, and we've even in cases where we have stopped a foreclosure, then with the client's help, we've been able to negotiate a modification of that loan and have that ultimately approved by the bankruptcy court, and they're in a better situation than they were before the case was filed due to the loan modification. So bankruptcy sometimes, I think, convinces these mortgage companies that, hey, we may need to look at a loan modification for these folks. So it's a great thing in a lot of cases.
And Robert, I expect to see much more of that. I spoke to a representative just yesterday from Best Case, which is a company you and I are familiar with that does software related to bankruptcy. And I'm aware that there is a movement nationally by the mortgage servicers to offer more modifications while in a Chapter 13 bankruptcy proceeding. I think the mortgage companies learned a lot back in 2008, 2009, excuse me, when they ended up foreclosing on a lot of properties and drove the value of homes down. I think more and more mortgage servicers are trying to work with people today to keep them in their homes Here I am saying something good about a mortgage company, Robert. Make sure you correct me on that. But
Yes.
but they are working with more people, and they're doing it through the Chapter 13 bankruptcy process. So all the more reason to reach out and get the advice and counsel of an experienced attorney. Robert, people are just overwhelmed when they come to see us. They have so many different collectors, so many different obligations. And you and I both know that money problems can create anxiety problems. They can create marital problems. Heck, the perspective of a father, or I guess a mother or any parent, money problems keep you from being a good parent, from being a good spouse, because you're just worried about things. We can help husbands and wife deal with their issues together. Bankruptcy is something that people can do together. Can you talk about that and how you've counseled people that have come in that have been under a lot of stress?
Yeah, I mean, day in, day out, we deal with people that are stressed, couples who are stressed, their marriage is stressed due to debt. And I've seen many cases where the filing of a case has made that relationship, has healed that relationship and made it better. Because now they're both actively working together, as they should, as a couple, to deal with their debt. And it is, reduced what they're paying out each month, or eliminated that payment or payments. And it's just, made their life much, much better. So again, that's why we want people to reach out to us who are dealing with debt, to see if we can, do something for them. If I can, help, if the bonus is that your marriage is stronger afterward, I mean, I think that would be a great, wonderful thing. I mean, because I said, I've been married for 31 years, and, marriage is tough even when things are good.
Yeah.
But, and we got to learn to work together as a couple, as one being, so to speak, as opposed to two separate individuals. So it's,
you're exactly right. And it's amazing to me how often I get referrals from pastors at my church, from faith leaders that do marital counseling, and they realize, this marriage is much more important than money problems. And they send people to us, and we're able to help people. So, if you're a husband, if you're a wife, you're a parent, the anxiety is getting to you, come up with a plan. Work together to come up with a plan to get yourself out of debt. Or if your spouse is, if you sense that your spouse is under a lot of stress, dealing with a lot of anxiety, needs a plan for a fresh start, tell them to reach out. We'll be glad to offer advice. And I want to say again, and I'm just going to take a short break here from my conversation with Robert. The Bond and Botus Law Offices have been helping people with money problems for over 30 years now. We've been around. We've done this for a long time. We're located throughout Alabama. We're located throughout Mississippi, and we're in the Knoxville area in Tennessee. We are offering right now absolutely free initial consultations with an experienced attorney, not with a secretary, not with some person that doesn't have experience. All of our attorneys are experienced. They've been helping people with money problems for a long time. And we'll do that initial consultation, if you prefer, over the phone, over video like this. We'll do it from the safety and comfort of your home or office. In fact, this is one time I can say, and again, I've been doing this for a long time, I've never been able to say this, we can handle the entire bankruptcy process virtually. The courts are holding hearings by phone or video right now. We can help prepare your bankruptcy petition if you choose that course virtually. We'll walk you through it from beginning to end. And now is probably one of the best ways to go through the process if you need to go through it. Reach out through the phone number on our screen, or reach out through our website, and we'll contact you and offer and set up that absolutely free initial consultation. Robert, we've talked generally about Chapter 7 and Chapter 13. I'm going to kind of give just an overview for our viewers of both and then let you chime in. Let's start with Chapter 7. So Chapter 7, as you said earlier, is a straight bankruptcy. For a lot of people, it's the best choice. I would say the best thing about a straight bankruptcy is it's quick. The whole process usually only lasts about 4 months. It's complete. You can discharge most of your debts, if not all, through a Chapter 7 bankruptcy. Now, there are certain exceptions. You can't discharge child support, alimony, certain marital debts, some taxes. Some taxes are dischargeable in bankruptcy. I would say that potential bankruptcy are, number one, with a straight bankruptcy, unlike the reorganization, you have to pay your attorney and court costs up front. Now, we'll work out a payment plan with you, but if the bankruptcy needs to be filed fast, that could be a hurdle. Also, if you're in a situation where you have an asset that you need to protect, like the example Robert gave where you're facing a foreclosure, or possibly an automobile repossession or a tax levy, those situations may call for a reorganization type bankruptcy so that we can make sure that you keep those assets. But you are able to protect certain property in a Chapter 7 bankruptcy. And I have never filed a straight bankruptcy where somebody lost a home where they didn't know they were going to lose it beforehand. Usually you can keep things like your home and your car. We very seldom have people lose any type of property when they file a Chapter 7 bankruptcy. What am I missing there, Robert? What else would you say about people considering Chapter 7?
A couple of things, Brad, and you mentioned one of those, and that is I think most people think bankruptcy means I'm going to lose assets or an asset. Not necessarily, and probably 98% of the cases that we file, no asset is lost. And in those 1 to 2% of cases where an asset is lost, we know going into the case before the case is filed that that's going to happen, and my client has understood that and knows that, and is as good with it as they can be, because the positive is they may lose an asset worth a certain amount of money, but they're gaining a much larger relief from much more debt than the asset was ever worth or is worth. And then the other thing I want to mention is a lot of people don't realize certain taxes, and I want to be very clear on this, certain taxes can be discharged in a bankruptcy case if they're old enough. Myself and several of my partners, we're admitted in the United States tax court, have experience on evaluating whether older tax liabilities to the IRS, state of Alabama, are dischargeable in bankruptcy. So we if you want us to look at that to see if you've got a tax issue, we'll be happy to look at that as well. So Chapter 7 is again, it is a good option for a lot of people, and it's a very quick process. And we're here every step of the way to guide you through it and explain it, and so that going into the case what you're facing.
Yeah, and one other thing I think people should be aware when they file a Chapter 7 bankruptcy. I always ask people, what do you think the worst thing that's going to happen to you if you file bankruptcy? And a lot of people, almost always, they'll say, well, my credit's going to be ruined. But Robert, I think you and I can both say that for the great bulk of people, by the time they call a bankruptcy attorney, unfortunately, their credit's already ruined. And in fact, bankruptcy isn't going to ruin their credit. It's going to be the first step in rebuilding their credit.
Exactly.
I want to make the point, when I first started doing this 30 plus years ago, we spent a lot of time helping people rebuild their credit. Now, And we spend time keeping people from getting into credit again, because as soon as you get your discharge, you start getting pre-approved credit card, you start getting letters from car dealerships. So what is the biggest thing you lose? Here's the biggest thing you lose when you file a straight bankruptcy, and people always roll their eyes when I tell them this. You lose your right to file another Chapter 7 bankruptcy and get a discharge for an 8-year period of time. And most people, Robert, as you know, they'll say, look, I don't want to be here now. Why would I want to file again? But we believe in what we do. Bankruptcy is a safety net. It offers a fresh start to people. So if you're going to file that Chapter 7 bankruptcy, be aware that you're not going to be able to get another Chapter 7 discharge for 8 years. I always like to tell people Chapter 7 is good if you're pretty confident, you've had financial problems due to a one-time thing, something like COVID that we hope will never happen again in our lifetime. Shed that debt that's accumulated and get on with your life. But if you're still going to be in a tight budget, if maybe you're still without health insurance or unable to meet, concerned that you may be unable to meet your monthly bills, then you may want to look at a reorganization type bankruptcy. Robert, technically there are 3 types of reorganization available to individuals. Chapter 11, people usually perceive as a corporate reorganization. It is available to individuals, but it's rare. Chapter 12 is a special kind of reorganization for a family farmer or fisherman. Again, it's rare, but we do have attorneys that handle Chapter 12 bankruptcies. But the great bulk of people that need to restructure their debt, they do that Chapter 13 personal reorganization, which is similar to a large corporation restructuring its debt. Robert, what would be some of the reasons why an individual needs to be in a Chapter 13 reorganization as opposed to a straight bankruptcy?
Well, I think several things. And first thing would be if you need to be in a Chapter 13, if you're behind on mortgage payments and possibly facing a foreclosure, or just behind on mortgage payments, and you want to keep your house. In my opinion, is one of the big reasons to choose Chapter 13. It's designed to catch up those back house payments so that you can really start fresh and not have to worry about making up the months that have been missed. If you're behind on a car and it's about to be repossessed, even if that car is a leased car, if you owe back taxes that we can tell under a Chapter 7 would survive and are not what we call discharged, which discharge is a term that means the debt is gone, wiped out, just to put it in layman's terms. Or you've got a garnishment of wages currently going on, and you need to get that garnishment stopped. Chapter 13 is a way to do that quickly. And so we look at your situation and you've got some assets that would be jeopardized in a Chapter 7 filing. There's Chapter 13 available to protect those assets. You don't lose assets in Chapter 13. That's because it is not the liquidation chapter of the bankruptcy code. So there's a few good reasons right there. Or a pending lawsuit, right? Where you're headed, where the next step would be a garnishment of wages. Right. That bankruptcy will stop that lawsuit that's going on. So again, getting back to how powerful the filing of bankruptcy is, that it just stops those things from going forward and gives you the relief that you need at that moment and to come up with a good repayment plan for these debts.
One thing I feel I need to say after listening to that great explanation, Robert, we get a lot of people that will call our offices, and the first question they'll ask is, how much will it cost to file a Chapter 7 bankruptcy? And I always try to talk to folks like that and say, number one, you may not even need to file a bankruptcy. It may not be your best, course to take. And number two, even if you need to file, Chapter 7 may not be the best option. You owe it to yourself. Bankruptcy is something you really only want to do once in your lifetime. There are some people that need to file more, but you really only want to do it once. And if you're going to do it right. Make sure you get the best advice you possibly can And I tell people, Robert, all the time, it costs a whole lot more to fix a bankruptcy that was done wrong than to simply do it right in the first place. We're not the most expensive people out there, but we're also not the cheapest. But I can tell you, you're going to get good, honest advice from the attorneys in our offices. So please feel free to reach out and get a thorough analysis and thorough explanation of how the different chapters work, like Robert just gave you on Chapter 13. So, Robert, we're starting to get some questions that are coming in here, and I want to give you a chance to answer a couple of these that are important to our viewers. Number one, what happens if I have a 401k or an IRA? Am I going to lose that if I file bankruptcy?
The answer is no. For qualified retirement plans, which most 401k retirement pension plans are protected from your creditors in a bankruptcy case. So the bankruptcy court trustee can't liquidate that asset, to pay creditors. So it is protected. And then, in Chapter 13, obviously it's the repayment plan. So, that's not, it wouldn't be at risk in that case either. So you're protected.
Just to elaborate on that for our viewer, one of the biggest mistakes people make is they try to withdraw money from their 401k or borrow money from their 401k in order to deal with debt. Talk to a bankruptcy attorney first. It may be a good idea to protect that money that you're going to need for your retirement for later in your life and explore bankruptcy options. Don't take that money out till you talk to a bankruptcy attorney.
Yeah, and on that note too, I mean, you realize too that for most people trying to withdraw from a 401k, depending on age, there's going to be a penalty for early withdrawal from that retirement or 401k. And then you're going to have some tax implication because that's income on top of your normal income. So it could lead to, when you file that tax return the following year in April, you owe a good bit of tax money to the IRS. And then, so you've created another problem. You may have paid off debt, but now you got a tax issue. So before you do it, check with somebody.
Absolutely. Check with Robert Reese, folks. Give him a call and he'll help you with it. Robert, this is another question or concern, I guess, that a lot of people have, and you addressed it a little bit earlier, but this viewer wants to know, is it true I'm going to have to sell my possessions if I file bankruptcy?
Typically, no. And so you're given, at least in the state of Alabama, you're given, state law gives you exemptions or protection of certain assets to a certain limit. So one of the things we look at before filing the case is we would look at your assets and the values of those assets to see if there is an issue, and be able to tell you and say, all right, if we go forward with this, here's what we're looking at. Here's what you could lose here, and I think in probably 99% of the cases, nothing is lost. So, but we want to be able to look at that, your assets and give you some advice, prior to filing, and so that you can take an informed decision whether to proceed forward. But again, I want to stress, it is rare that people lose any assets or are required to sell those assets.
Well, I want to underscore what you just said. It's very, very rare that you're going to lose any assets if you have the advice of a competent bankruptcy attorney. That caller I referenced earlier that says, I want to file a straight bankruptcy, how much is it going to cost? That's somebody that may not realize that they could lose property with a straight Chapter 7 bankruptcy. Don't just assume that one chapter or another of the bankruptcy code is best for you. Make sure you fully understand the ramifications of each.
Yeah. And there's an old saying too that says, the most expensive lawyer you'll ever have is the cheap one.
Right.
And I see that playing out in court and have for the last 25 plus years, unfortunately. So
it's sad when you see somebody that's not represented well.
Yep. Unfortunately, that's Unfortunate, very unfortunate, but it does happen.
This person, and I think you may have answered it in your last question, but let's elaborate. Can I keep my car if I file for bankruptcy?
And the answer to that is typically yes. And we can address that depending on, which chapter you're seeking and or decide to file. And typically in a Chapter 7 or straight bankruptcy, if you financed a car, as long as you're current on the payments and you've got the car insured with full coverage insurance, the finance company is happy to allow you to keep it and continue to pay them. You then, as part of the bankruptcy process, you enter an agreement with that finance company. We call them reaffirmation agreements, which means you're reaffirming or recommitting yourself to that loan as it exists at that moment in time. It doesn't typically change any of the terms of that loan. So, that's, you won't necessarily lose your car unless you decide you don't want that car any longer. In a Chapter 13, you're typically going to be repaying, you're keeping that car and paying it through that reorganization plan. And the good thing about Chapter 13 is we can, depending on the interest rate, if it's a high interest rate car loan, we may be able to reduce that interest rate down to a more reasonable interest rate. And in more specific circumstances, if the car was purchased, at least 2.5 years prior to the case being filed, we may be able to, depending on the value of the car, you may only have to pay the value of the car plus a reasonable rate of interest, which again, when you start looking at it over a period of several years, there's huge savings in interest, principal and interest under that example I just gave. But again, we got to look at those each case on a individually to see if that's even an option. That's something we look at in every case.
It's always great when you sit down with somebody and they've come to see us because they may be 3 or 4 car payments behind. They're paying a whole lot in interest. They're worried about repossession. And we analyze the situation. And this happens often. And we come up with a Chapter 13 reorganization where their payment, not just to take care of their car, but their payment to take care of all of their debt is going to be less than what that car payment was. And, they're no longer behind on the car. The car can't be repossessed. They've got a plan moving forward.
Yeah, that's exactly right. And I've seen that numerous times, more than I can recall, but many, many.
And it's great. And, again, always before you get to that point where a repossession is imminent, talk to an attorney and understand what your rights are. Things happen to people. You may not be making as much money as you were when you financed that car. The payments may be tough right now, or something's happened that's caused you to get behind. There are options available. Robert, this next question, how long does the bankruptcy process take?
It really depends on obviously which case you're pursuing. With a Chapter 13, I'd say at least my experience over the last few years from when someone decides to hire us and retains us to the filing of the case can be anywhere from, a week to 2 to 3 weeks, just gathering all the information that's needed, really reviewing everything in great detail and preparing the documents that have to be filed with the bankruptcy court. We commonly refer to that as the petition, which is a pretty lengthy document. So there's a lot of work that goes into the front end of the case. But we can file cases quickly when it's necessary if there's some emergency, but probably on average a 2-week time period from start to finish. And then obviously with Chapter 7, with the attorney's fees and court costs needing to be paid before we can file it, sometimes that takes a little longer depending on how quickly a client is able to pay those fees. So in Chapter 7, it can vary from just a couple of weeks to maybe 30, 60, even 90 days.
And I would elaborate. Those are average times, but folks, we can, if necessary, file a bankruptcy very quickly. I don't want you to wait to this point, but if you are at the point where you're at the cusp of a foreclosure or a repossession, or your wages are being garnished, we're going to need your cooperation and participation in gathering the necessary documentation. But we certainly are set up to file a bankruptcy very quickly if need be. As far as after we file the bankruptcy, we talked about this earlier, normally a Chapter 7, the process from the day it's filed to the day it ends when you get your discharge is going to be around 4 to 5 months. Chapter 13, it's up to you. It's usually going to be between, a minimum of 36 months, a maximum of 60 months, because again, you're putting together this plan of reorganization to pay your debt over time. So it's going to take a little bit longer. Robert, what can I do if I'm a small business owner? So we're seeing a lot of folks like this, folks that had to shut down their businesses, over the last year. So, and we often get this person wants to know, do I declare corporate bankruptcy or personal bankruptcy or both? What do I do?
My experience has been typically that it's going to be a personal bankruptcy because the individual or individuals have personally guaranteed the debt that the LLC or the subchapter S corporation owes. So it's typically, like I said, going to be a personal bankruptcy, but not always. I mean, there's going to be exceptions to that. But that's what I'm typically running into now is not only do they have corporate LLC debt that is personally guaranteed, on top of that, they've been using their own personal debt or personal finances and credit to help keep the LLC afloat and do payroll, keep the business running. So when we look at the overall picture with both the personal and the corporate debt, which is personally guaranteed, it makes sense that it most likely be a Chapter 13, for personal, not necessarily the LLC, the corporation. That's actually pretty rare in my experience.
This is one of those instances, though, if you're a small business owner and you're starting to have financial problems, this is one of those situations where you need to reach out and talk to a bankruptcy attorney sooner rather than later. I've so many people want to do everything they can to make that business survive. And as Robert said, they've dipped into their own finances, or you may have used your own credit cards or borrowed against your home or taken money out of your 401k. Those may not be good options. Before you do that type of thing to keep your business afloat, consult with a qualified bankruptcy attorney. We'll talk to you about things that you should and shouldn't do. But we feel your pain. Our law offices are small businesses. We have to meet payrolls and expenses every month. We're going to sit down with you and we're going to help you figure out the solution that's best for you. If you have personal guarantees, if you've expended personal debt, though, we need to look at the whole situation. We need to look at your situation individually as well as your business situation. Robert, one more question, and we addressed this a little bit earlier, but I think and this question has to do with medical debt. I think a lot of people have this view in their mind that medical debt is somehow different in bankruptcy. So this person says, are medical bills wiped out if I file bankruptcy?
Well, the answer to that is yes, under a Chapter 7. And of course, under a Chapter 13, that medical debt will either be paid back or a percentage of it paid back. And in some cases, as Brad mentioned earlier, is that medical debt will not be paid anything, but still discharged under that Chapter 13 case. There's nothing special about medical debt. It would be covered under either bankruptcy option.
Yeah. And there have been studies for our friends out there that have demonstrated that one of the biggest factors leading into bankruptcy for a lot of people is medical debt. We see it all the time, Robert, I know you and I both, there's this stereotype out there that somebody that goes to see a bankruptcy attorney is some kind of deadbeat or somebody that, tried to avoid paying their creditors. In the vast majority of cases, people that come to see us are good, hardworking people that have had something bad happen to them. And often that bad thing that's happened is health related. They've been injured, they've been sick, they haven't been able to work. And it's not just medical debt that piles up when you get sick or when you're injured. You have to use credit cards to buy groceries. You can't pay the rent. You can't pay your mortgage payment. Things happen, and we don't represent bad people.
Definitely not.
People that come to see us we try to treat them like family. You come and let me just explain the process at the end here for our viewers that may be facing financial challenges or think they're going to have financial problems in the future. If you call our office or you go to our website, what we're going to do is we're going to find a time that's convenient for you, and we're going to schedule a consultation with one of our attorneys. We hope to be meeting in person, again, just as soon as possible. In some instances, we're doing that now with appropriate social distancing. But if not, we'll set it up over the phone or by video, and you'll have a chance to talk with an attorney about your situation. We'll ask you to fill out a short information sheet before the consultation, and we encourage you to do that so that we have a good understanding of what's going on, who you owe, what you own, where you're working, if you're working right now, and what type of income you have. And we're going to evaluate all of those factors, and we're just going to talk you through the situation. If we can avoid bankruptcy, we're going to do that. If we can just help by, in getting collectors to stop calling you, there are options available there. If you want us to help review your credit report and look at collectors that may be improperly listing debt, we can help you with that. If your best option is going to be to try to refinance, we'll advise you to do that to work your way out of debt. We're going to look at all the options, but if bankruptcy is the best option for you, it's not just a simple process. We want to go through Chapter 7, Chapter 13, all of your options, and let you know in advance how those type bankruptcies are going to impact you. Robert, we're getting close to an hour's time, and I like to keep these episodes below an hour, and I want to be respectful of your time. Do you have anything I've missed that you'd like to share with our viewers about how we help people and about the bankruptcy process?
Well, just one thing that you were kind of alluding to a little while ago about filling out information for us. And I always want to stress to people that when you fill out and provide us information about your finances and your income and questions you answer for us, it is strictly confidential. When we talk and meet, there's something called the attorney-client privilege that prohibits me from discussing that with anyone. So don't be afraid, and again, don't be fearful of giving us information, because I'm only the advice I'm giving you or we are giving you is going to be only as good as the information that you provide us. And that is so critical, because the last thing we want to do, or any attorney I know wants to do, is give bad advice. We want to give you good, solid advice. And so don't be fearful of providing us information. It is extremely important, and it'll go a long way in making the process much better.
Yeah, not only is the information you provide us with confidential, the entire communication is confidential. Nobody's going to know you reached out and talked to a bankruptcy attorney, especially now. We're doing these by video or telephone. We're going to keep your information. We're going to keep the fact that you reached out to us confidential. And folks, even if you seek bankruptcy protection, it's not like there's going to be some mark going forward that indicates you as a bankrupt. I promise you there are people around you that you encounter every day that have been through the bankruptcy process, and the only change may be that they're smiling a little bit more because they have some peace of mind and they have a weight off their shoulders.
Sure.
Robert, thanks so much for sharing your advice, your wisdom today. Thanks for everything you do for our clients. And I want to just tell our viewers, on behalf of all of us at the Bond and Modus Law Offices, we wish you nothing but the best in 2021, and we're available to help you if we can. So God bless all of you, and we'll see you next week. Thank you, Robert.
Brett. Thank you.
Bye.
Bye.